My name is Kiati. I'm head of Joshi Advocates. Thank you very much for joining us in this video. This is in the next 5 minutes a JR judicial review in an immigration related aspects on what basis, merit, process, and the story to go with it. So let's go on the journey. We have been on the journey for the last 2 years. So let's see how it ends. So now JR is where a person is saying that a public body has made a decision which is unlawful, irrational, unreasonable. Specifically identifying exactly what A, the decision is, and B, what law is it contravening, and 3, maintaining the procedure. So what is a procedure? First, make a pre-action protocol letter and give it to the relevant party in the public body. In this video, we're looking at the Home Office. So the pre-action protocol letter would be served to the Home Office and allowing them 14 days to respond. So the client came 2 years ago from Coventry through YouTube, thank you very much, and he had been granted 3 years discretionary leave in 2012, and then another 3 years discretionary leave. So I'm thinking 3 plus 3 is 6, right? No, Home Office is saying it's 30 months. Now, I am no mathematician, but I think it should be 6 years, and as a result, a route to indefinite leave to remain settlement. So Home Office said no. In fact, Home Office decision said he benefited from the additional months, whereas he should have been granted initially in 2012 30 months. And he should not have been granted the extension of 3 years also. That also should have been 30 months, based on the caseworker's notes in 2012. All right. So we identified the policy, we identified the law, the circumstances, all the evidence is there to support the application for permission to judicial review against the Home Office. So if the pre-action protocol letter, Home Office says no, we don't accept what you're saying, next step would be in 3 months of the Home Office decision that you are challenging, you must issue this application in the court, permission to judicial review. When you put the application in, Home Office lawyers will respond. And then the judge on the papers will look at whether permission should be granted or not. There is no oral hearing at this stage. So in this case, the judge refused permission to judicial review. Now, moving forward then, we knew we had the policy, we knew our interpretation was correct. So we advise the client, let's press on, let's move forward, let's pay the court for the second stage court fee of judicial review or a reconsideration, where the judge will give you the benefit of audience and listen to the argument fleshed out, but it's still permission stage. So you would only best get permission from the court to issue judicial review proceedings. So we went to the hearing, and the judge asked the Home Office, why are you saying that the client applicant should have been granted 30 months based on the caseworker's notes? If that's so, where are the caseworker's notes, or where's the record? Home Office, we don't know. So then the judge said, permission is granted, success, and we were jubilant there. Now, at this stage, Home Office can do 2 things. They can withdraw the decision because they know it has merit, or not withdraw and proceed further. So in this case, we prompted the Home Office, withdraw. You know it has merit. You don't have the records to support what you're saying, and we have the policy on our side to support that he should be given indefinite leave to remain. So anyway, they didn't accept, and the client applicant paid a more court fee and had the oral substantive JR hearing. Rarely immigration judicial reviews get this far, rarely, because most likely Home Office will withdraw. So it becomes more and more dangerous. And why does it become dangerous? Because there's a cost element. Forever, throughout the proceedings, the client is informed that if we don't win, there will be legal cost implications. So he will have to pay the Home Office lawyer's fee. So of course there is that pressure. And all the while there's pressure to say, we should win, this is the policy, continuously informing the Home Office. But we go to the court and Home Office says what they have to say, we say what we have to say, and the judge says, okay, thank you, make a decision. So in the middle of May, we got the decision, and we had been granted our remedy, which was that the Home Office is unlawful. So our judicial review was successful. However, there are two good things here. One, we win, but also not completely, because the process may continue. But the second good thing is the client can recover the money he spent in costs and get it from the Home Office. The Home Office would have to pay him his lawyer's fee. Now, after the court decision, we thought maybe the Home Office would appeal it further, so it was very anxious. And hopefully, we sort of emailed the Home Office, but it was COVID-19 time and it was difficult. But we pressed on, and Home Office emailed after 6 or 8 weeks and said, no, we're not going to appeal, and the decision should be coming soon for indefinite leave to remain. And today is the amazing day where we finally have our indefinite leave to remain decision and the BRP card, the biometric residence permit, endorsing settlement. So after 2 years, and get this, the costs he's going to get back from the Home Office is going to be just shy of £10,000. £10,000. That's a lot of money he has spent, but he's free, and he's lucky that he can recover the cost. And we won. He was in good hands, and now let's see how we move forward. But I think this has been amazing. Thank you so much for joining in this journey. As always, subscribe, contact details below, and I'll see you next week. Take care.